Lena Hornkohl, Eddy de Smijter, Marek Martyniszyn, very warm welcome to Digital Markets Research Hub. I was really looking forward to this conversation for quite a while. You three are great specialists in various aspects of competition law and policy, but today's conversation will be on the one which is rather not distant, but is not the mainstream topic for our ex-post nurtured minds, competition minds, but now we are entering into new, much more proactive area where competition policy is not insulated, is not inward looking only. We are learning gradually how to interact with other adjacent areas of law and policy. And today's topic is one of the best examples how this interaction takes place. We will be talking today about foreign subsidies control, the new regime introduced by the European Union. And you have published and acted on several occasions, and you are seen as a leading actors and thinkers within this field. So I'm very grateful for this opportunity. And I propose, as a starting point, maybe we can just remind to all of us the main objectives of the new regime, the main characteristics. We will be talking about nuances, but let us start with the broader kind of outline. Eddy, maybe we can start with you.
Yes, good afternoon, and thanks, Olesz, for giving me the opportunity to explain indeed the rationale behind the foreign subsidy regulation. The foreign subsidy regulation, one may say it's remarkable that it took until 2023 to have a regulation on foreign subsidies. We have state aid control already since the very beginning of the European communities back in the 50s, meaning that we do control the public financing of our member states, and the reason being that we cannot let those member states with the deepest pockets to create barriers to the internal market. At the same time, the European Union is an open economy. We have a lot of foreign investment in the Union, and I think that's a good feature of the internal market, and we should by all means maintain that. But those foreign investments in the European Union sometimes go along with foreign subsidization. Now, it is remarkable that for decades we have had a control of the public spending of our member states, but hardly any control of the public spending, the subsidization of non-EU member states on economic activities taking place within the Union. That means that economic actors within the Union either were getting their money from a member state and then there was state aid control, or they got their money from a non-EU member state and then there was no control. Meaning that those companies are not necessarily competing on the merits, but you compete on the basis of the one who gives you the most money. And hence, our feeling in the Commission has been for a long time, let's create that level playing field. The best way to do so would have been, and still is, to make sure that there are global rules on subsidies that make that there can be a level playing field created globally. And that is why the Commission has tried and continues trying to modernize the industrial subsidy rules in the Agreement on Subsidies and Countervailing Measures. That process takes a very long time, and we have mixed successes, to say the least, which meant that we got from the European Council a demand to, in the absence or awaiting the multilateral rules on subsidies, to make sure that we have our own rules creating the level playing field that we need. And that is the origin of the foreign subsidy regulation that entered into force last year. I think more or less the same day, no, was it 12 January, if I'm not mistaken? So more or less 1 year of entry into force. We should celebrate.
Yeah, true. Good day to record this, I think. Yeah. But I mean, I think it was also a little bit of political momentum. I mean, as this new regulation, it was not in a state aid modernization package or anything like this. It's under the framework of open strategic autonomy and all these new rules that we have on international trade in the EU or that are prepared at the moment. And I think in the end of this month, we have a whole new foreign direct investment package. So I think it was a little bit, you know, the political momentum to have more control over also, you know, outside of EU market influences. I think the whole discussion kicked a little bit off in the context of the Siemens-Alstom merger, and then having more competitors from non-EU states, and a little bit also the lack of EU industrial policy. So everything plays a little bit into this. I always call it like the cherry picking regulation that picks a little bit from everything, and also the objective is a little bit from everywhere, which I think, I mean, does not only make it interesting for researchers, but also for practice. You know, nobody really knows which department of the new law firms are supposed to take care of it. Is it the competition lawyers, the procurement lawyers, or who should take over?
And we have great opportunity to unravel this legal administrative labyrinth. We will do our best, but as a first round, Marek, can you please explain maybe to us your understanding of when we were talking about the DMA, it was clear who are the stakeholders, who are the main addressees, who are the main beneficiaries, what are the objectives, however vague the objectives are in terms of fairness, contestability. What is at stake here? Who are the main protagonists? Who are the main critics? Elucidate, please.
Thank you so much, Olesz. Let me follow up briefly on what Eddy and Lena said, just to complement. I agree with what all has been said. Eddy talked about the lack of regime, a lack of discipline in relation to subsidies, so extra money is granted by non-EU states to firms operating on the EU market. And that's indeed true. And I would say that until now, we've been looking at a system with effectively reverse discrimination. So if you were getting subsidies from EU member states, you had the state aid rules, which are quite demanding. But if you were getting monies from elsewhere, that was perfectly fine. So yes, I fully agree, we're lacking this level playing field. Now, you interestingly mentioned in the introduction that FSR moves us beyond the ex post mindset. And that's quite an interesting question, and I hope we'll touch on this issue, because as we know, it can apply ex ante, but it may apply ex post, right? And that's a quite interesting possibility, which I think should not be forgotten. And one more thing about the lack of global rules. So it seems to me that this is yet another area where EU, which is quite, I believe, collaborative in nature, which has collaboration in its DNA, is taking steps due to the lack of multilateral solution and perhaps a crisis of multilateralism. We've seen that when it comes to extraterritoriality in competition law itself, EU was quite careful and was pushing for multilateral rules within the World Trade Organization. And things expanded considerably in the EU after that project failed in the World Trade Organization. So this is not so surprising. And I would say that I would be one of many people who would agree with the idea that having global rules in this field may be extremely difficult, not least because we don't have such a rules even at the federal level in the United States, where different US states compete against one another. So not having major trading powers already interested or already having such rules internally may be quite tricky. And perhaps I stop here.
Without answering my question, Marek. Right, so let us then look at in more detail how many elements or what is the proportion from different regimes, currently existing regimes, does this FRR new modality absorbs? What are the reasons and how it positions, identifies itself as an autonomous EU policy? Eddy, please.
Before doing so, shall I reply to your question, Olesz? Who are the addressees of the FSR? And it links a bit to what Marek mentioned on the ex-post. In state aid control, we have an ex-ante system where intended aid, not yet granted, needs to be notified to the Commission. And that is where the state aid control comes in. Obviously, you cannot do that with third states. You cannot ask third states to inform us on the aid that they are intending to grant. So you necessarily come after the aid, the subsidy has been granted, which means that the assessment, and we may come to it later in this session, the assessment of the effects of the subsidy are different under foreign subsidy control than under state aid control. That's because of the nature of coming after the subsidy has been granted. The affected addressees are therefore not the states. Third states are obviously free to give the subsidies that they want to give, and that's part of their sovereignty. But we are, as a European Union, also entitled to check upon the effects of those subsidies, the effects on the internal market. And I heard a number of people saying that, in fact, we are targeting foreign companies, which is incorrect. We are targeting the foreign subsidization to any company active on the internal market. That's not only an issue of non-discrimination, but also a kind of reality check. It would have been otherwise too easy to circumvent the rules by simply saying, we set up a European company and we can freely let the subsidy flow in. So all companies active in the internal market are an addressee. And that's also a slight difference here with the state aid rules, which are, as I said, focusing the states. Here we're focusing on the companies. And it has led amongst the companies to, I mean, a new reality, new rules that they had to live up to with compliance officers in companies now for the FSR. Now the question you just addressed. If I'm talking too much, you stop me, Olesz. It is clear again with regard to the non-discrimination principle that we cannot be stricter vis-à-vis subsidies coming from third states than we would be vis-à-vis state aid coming from the member states. It would be awkward that the Union considers aid from a member state to be compatible and identical or similar subsidies from third countries, that is considered distortive. So the state aid acquis is clearly a source of inspiration for the enforcement of the FSR. I think that is for us our main benchmark when we're looking into cases. What would have happened if this aid was to be granted by a member state? What would we have said then? That is for us the benchmark in finding distortions. And obviously, we are also closely linked, at least for concentrations, to our colleagues enforcing the EU merger regulation, because given the thresholds in the FSR, and the reality shows that now, almost all of the concentrations notified under the FSR are also notified under the EUMR. That's more of a practical sister, whereas state aid is our benchmark, the EUMR control is more, from practical reasons, our sister enforcer. On the substance, the EUMR colleagues are looking at something completely different. the CIEC test and the significant impediment of effective competition is relevant under the EUMR, not for us. That is not something that we are checking. We are looking exclusively into the effects of a foreign subsidy on the concentration process or on the position of the company post-concentration on the internal market. But the effects, not by bringing numbers 2 and 3 together and thereby creating a position that leads to a significant impediment of effective competition, but the effects of the foreign subsidy. So the merger control test, and I know that a lot of practitioners think that we are doing more or less the same, and some even inquired why we have not modified the EUMR. That would not have been a good idea, because the test here is completely different. But since the notifying parties usually notify in parallel to us and the EUMR colleagues, as I said, it's a sister enforcement. But the benchmark is the one of state aid control. And then FDI control is something that comes on top of a possible trio of commission enforcement. If you're lucky, you can have FDI, EUMR, and FSR. But as you know, in FDI, for the moment, as the regulation stands, the Commission can only give an advice to the relevant national authorities as to the effects of a foreign investment on the national security that one has within the European Union, which is a test that we are not looking into. So you have complementary tests in 3 different instruments. Some may say that is an additional complication. I would invite you to imagine the world if all of that would have been in one regulation with 3 different tests. I think it's now clearer that for every substantive test, you have a different legal basis. I think for the practitioners, that's easier to look into than if there would have been an amalgam of all those objectives into a single regulation.
Many thanks indeed, Eddy. Lena.
What can I add? What can I add? I mean, I think when Eddy was doing the tour around Europe to all these different conferences, he always had the same presentation he brought with him, and there was this nice wheel where it showed like quite nicely how the FSR has this gap-filling function, I think. And as Eddy said right in the beginning, it was pretty clear that we needed something to fill the void of for external for the lack of external state aid control. I was just wondering how, or I'm always asking myself how realistic it is in the end, and I think we will see when we see the first cases if a third state will actually give a substantial amount of money to EU companies, because what would their incentives be? So why would a third state give a huge amount of subsidy that could be problematic under the FSR to a company from the European Union outside of using that, for, let's say, non-competition reasons, so for strategic reasons? And I was always wondering, that can we really does the legal test really reflect that problem? Or if we look at this nice wheel where the FSR was supposed to fill a gap, don't we still have another gap because we do not have a proper EU FDI control? As Eddy rightfully said, it's the member states who look into national security, but are we not going a little bit into the direction of needing, EU security concerns, specifically vis-a-vis member states who have a different view on national security and who have no problem with selling their main ports off to third states? So do we not still have a gap in this in the regulatory framework? I'm asking myself. Maybe Eddy, you want to react, or Marek? I don't know.
Let us start with Marek, and then we'll revert to this really intriguing question to Eddy.
Thank you so much. And yes, let us name that case. So for me, the case in point, of course, is Costco. which is a huge Chinese state-owned shipping firm, which has minority stakes in over 10 ports in the European Union and wholly owns the biggest port in the Mediterranean Sea in Athens, which they purchased when during the financial crisis, Greece was required by IMF to sell off that asset. And that created indeed quite a bit of turbulence in Europe in terms of whether that transaction should be permitted. I recall the conversations in German media about it. I believe that 6 federal ministers in Germany and 2 intelligence agencies were against that, as well as Robert Habeck, the deputy chancellor, whereas Chancellor of Scholz, who is indeed from Hamburg, and that case concerned the port of Hamburg, was in favor of it. And if I correctly believe, at the end of the day, the minority stake was limited so as not to fall within merger control rules, and the Chinese company lost possibility of having a member of the board, right? And that was indeed a very interesting case, potentially leading also to the, tying nicely with institutional design of this regulation, which basically gives exclusive competence to apply it to European Commission. I understand that when these ideas were being considered, at some stage there was hope that different member states will be involved in application of these rules, and indeed not to have countries being played or playing one another against one another. That competence was vested with the European Commission. Yeah, thank you so much.
Eddy, do you want to add to this question shaped by Lena and partly answered by Marek? And maybe once to continue to move more closer to the issues of priorities, obviously with such, particularly to the competences which the Commission has ex officio, you obviously have some discretionary room. And maybe it is too early to anticipate, but at least provide to us some hints, at least, where would it's the most probable the focus will be placed.
Okay, first on the point that Lena raised, without going too much into FDI control, which is not my portfolio, I see your point, Lena. But as you know, at the time that the FDI regulation was adopted, the desire of the member states was to keep that control to them. And it was considered far too sensitive to give that power to the European Commission. Maybe minds have evolved since then, but it is considered by the member states too important to keep, too sensitive, I have to say. I should not give the impression that only important stuff is maintained with the member states. No, it's too sensitive, which was a very different logic when we were discussing the FSR regulation in the Council, where there was fairly quickly an agreement amongst the member states that this is an enforcement that should be given to the Commission because of its close link with state aid control in terms of the kind of benchmarks that you have to set, and that if there would be an investment in, say, member state X, is then member state X the one who is competent to see whether or not that investment is involving distorted foreign subsidies? Is that the best placed? So there was quickly amongst the member states an agreement that it would be better for the Commission to do that control. If ever the FDI regulation would be widened, either because of who is enforcing or what are the grounds for intervening, I think that the basic principle of FDI control will always be to prevent a foreign government having an impact on issues of security. Now, national security, who knows in the future, EU security. Funding is, in that respect, only one element that could hint at possible foreign government intervention. So you see under FDI control, the intervention benchmark is higher than for us. We don't need to show that there is a big master plan behind it for a government to take over control on some sectors. We only need to trace the money back to foreign governments. And once there is this flow of foreign money, then we can intervene when there is a distortion of the internal market. And those distortions are taking place, we have seen, in a lot of sectors. Since the regulation entered into force and already before, representatives of a lot of sectors came to see us to say, finally, we have been suffering from an unlevel playing field for all that time, and now there is the tool for you to intervene. Which begs the question, Oles, which cases shall we take first? Where do we prioritize? Of course, for notifications, we take them as they come, because that is more demand-driven. But on the ex officio, we can set our priorities. And I'm not going to give you any indication of where our first cases will be, but I hope that you will be seeing them soon. I think that it goes without saying that we will focus on those cases where we believe that there is an impact for the internal market, an important enough impact on the internal market. We know that in some member states at the border of the European Union, there is a higher risk of distortive foreign subsidies from their neighboring non-EU country. But there's also, I mean, that foreign subsidy may only have a local distortive effect. I'm not saying that local distortive effects are not bad. I'm simply saying that in terms of priority setting, that we have to look at those cases where the distortive effect of a foreign subsidy is important enough for the Commission to intervene. And as I said, sectors I will not mention. Any sector can potentially be affected here.
Any sector can potentially be affected here. Thank you very much, Eddy, for this, for exposition of this rather demiurgical competences bestowed on the Commission in this regard. Lena, what are your views on this new modality, reality?
Well, I will answer this in a second. I just have one more thing to say towards Eddy, because I just feel like, you know, we don't know what you will do, and you have explained super clear how there's very, very important areas where we need this instrument. It's just, I think the regulation, at least the way it is worded, and the priority setting possibilities that you have, gives room for considering, you know, at least EU security concerns. And again, as I said, you know, while financing is one aspect of this, I think, yeah, with the open test that we will have, or that we are having now under the regulation, I think impact on security could be, at least in practice, something that would be relevant, specifically given that there's not really an FDI control on EU level. More
on that, sorry to interrupt,
Yeah.
Lena. I'm not disagreeing.
Mm-hmm.
And the only thing I wanted to say is that it is not limiting us to security aspects, which for FDI is limited to security. But you're absolutely right that we could also, if there is a distortive foreign subsidy in the security sector, then yes, the FSR could be applied. Sorry to interrupt. Simply
No.
to confirm what you said.
And then, I mean, I think I'm the wrong person to ask about, you know, theories of harm and like how the test will be applied here. I think it will be again be Eddy, because I mean, from the wording and, you know, having a strictly legal interpretation of this, it comes very close to what we have in state aid law. And but at the same time, you know, in state aid law, we have 60 years of successful jurisprudence, a lot of guidelines, a lot of nuances. And I think this is probably rightfully still missing at this point, you know, because where do the guidelines and all these things, notices come from case law experience? And we don't have that at the moment. We are all watching. The commission press releases here, I think. So I think for that we have to go back to Eddy to see, you know, the main objectives in the terms of, you know, theories of harm. I can only imagine that it will be very close to state aid law, as this, you know, if it's supposed to fill a gap in state aid law, it's supposed to be applied the same way, and then we should use the same theories.
The wrong person to ask, and then the punchline. Let us ask another wrong person. Marek Martyniszyn, what is your punchline?
Well, let me share with you a couple of ideas which I think relate to what was just said. I'm not sure whether you've seen the cover of this week Economist. There's a lovely cover about electric vehicles, right? And without going much into substance of what they are telling us in the Economist, they raise quite a lot the question of subsidies and the fact that China now exported more vehicles than many other states, and that they are extremely competitive when it comes to prices, right? Apparently, the punchline in that article is that their exports are just limited by their production capacity. And I recall a variety of European car makers raising concerns in that space. And I find that quite interesting. Now, I very much like what Eddy said about the way Commission may apply the regulation. I recall a sentence about the regulation by our competition commissioner, who said that the regulation designed to catch the big fish, because only the big fish has the teeth to do the damage to the internal market, right? And I think that very nicely encapsulates what may happen. Now, I love this comparison to animals. So she talked about fish, and I'll talk about dogs. So is that a dog that barks a lot, but doesn't bite? Or is this a dog that is going to bite, or a little bit of both? And of course, we talk about barking. So this may be the issue of signaling. We are not willing to continue with undermining level playing field in the European Union. And we know that EU has been extremely successful with soft law approaches. And sometimes signaling may be good enough to achieve a variety of aims. Or are we going really to look at significant biting power? And I hope we get to this point, because there is a variety of interesting aspects of this regulation which are extraterritorial and where we'll need a lot of more clarity going forward. Thank you.
Thank you very much, Marek. Eddy, you are the right person to ask that question, but I will not be asking it to you because you are a diplomat and so much is at stake. But you're welcome, of course, to provide some hints to us. You already provided quite a few implicitly. Let us move to the legal mechanics, so to say. Just to summarize to us, enforcement. We already got the key message that it's centralized, country to FDI, where most of the competences are within the member states. But maybe also tell us more about, as question to all three of you, about the notification, the mechanism, procedures. There are three main types. How are you expected to implement the strategic objectives into legal matrix?
Maybe first to react to Marek, I will not come up with a third animal. Just I think that we are in a fast-moving society. A regulation enters into force in January, becomes applicable in July, and within a couple of months later, you want the Commission already to come out with an enforcement decision. I wonder whether in the 50s and the 60s, people were equally impatient. I think we want these cases to have to be solid. And so, as I said, one has to be patient for the first cases to come. but I don't think that that this dog will only be barking. Simply asking for some patience. On the enforcement itself, the regulation, as you said, Oles, has 3 parts in enforcement: 2 notifications, 1 ex officio. In the notifications, we have notifications on concentrations, and we have 1 on public procurement. In DG Comp, we are enforcing the concentration notification part. The notifications on public procurement rest with DG Grow, who were together with us negotiating the regulation, who are also master of the EU acquis on public procurement, and therefore know better the setting in which to enforce the notifications for public procurement. On concentrations, I can tell you that now we are 3 months after the start of the notification obligation, and we are in contact with 50 companies, 50. So we have 50 companies that have pre-notified their deal to us, and the pre-notification discussions are the most important part of the discussion in this first phase, because it allows us to explain to the companies and their legal advisors what is the information that we are looking for when they notify their deals. And the interaction, I must say, is very constructive, both with the companies and their legal advisors. We are looking into foreign financial contributions above a certain threshold. And we are also interested in sometimes in the governance structure of the financer. For us, obviously, in order to make it possible, make the attributability link to the foreign government, and in order to be able to determine whether or not there is a subsidy. Once a subsidy has been determined, then we check whether or not the foreign subsidy at stake in the concentration process is distortive or not, either of the concentration itself, because the foreign subsidy may have allowed the recipient of the subsidy to make a higher offer, but it may also be that the foreign subsidy remains influencing, as I mentioned before, the merged entity post-concentration. And also that we should, in the concentration module, be able to correct. That's a bit the model as we have it under the concentration chapter. So far, as I said, in touch with 50 plus companies. We have already closed, I think, about 5 to 10 cases in the meantime, without opening a second phase in which we would go a bit deeper into checking the subsidy nature and the distortive effect, and where also possibly the balancing test would come in, which is linked to what Lena mentioned earlier on the compatibility guidelines. If aid is, on the basis of our guidelines, compatible in state aid terms, then we would also find that subsidy to be balanced, not necessarily outweighed, but balanced by positive effects. So that is what we do under concentration. And under ex officio, we either send out requests for information or we do an inspection, and on the basis of that are collecting information in order to find to see whether there are distortive foreign subsidies. I don't know, Oles, whether with the legal framework there was something else that you were looking for to explain further.
Just maybe a very short clarification. So ex officio, is it within the competence of DG Grow or DG Comp? And what is the connection? What is the, we know that DG Connect and DG Comp we kind of already start understanding better about this closer cooperation between DGs. what is the stake and what's the situation with DigiGrow?
So yeah, for us it's indeed Grow. It's Connect is for the DMA. For us it's DigiGrow. On ex officio, they are taking the ex officios on public procurement, and the remainder is with DigiComp. The two DGs are autonomously doing their cases, in the sense that notifications and ex officios, the both DGs are proceeding as they see fit. However, because we are both applying the same concepts, and obviously that's true for the ex officios, but also when you compare the two notification chapters, there are similar concepts being used in the two chapters. We are regularly in touch with each other to make sure that we interpret those concepts in the same way. So the contacts with DigiGrow are mainly about how to interpret particular parts of the FSR that we have in common. That is also why when we issued the Q&As, we have now already 3 series of Q&As on our website, that we consulted with DigiGrow before publishing those. It would be awkward that the Q&As of DigiComp and DigiGrow would be different on the same concept. So we do concert regularly, but the cases we take autonomously.
Thank you very much, Eddy. Let me forward this question to you, Lena. I mean, the broader, what are your reflections about the new regime?
Well, I mean, I think Eddy has painted the bigger picture of having two notification-based and then this ex officio tool, which for those of you who do not know the regulation as well, can really be anything. You know, it can be below notification concentrations or procurement, but it can be greenfield investments or basically any kind of economic activity. And then, as Eddy also said, it lies within the Commission. So during the legislative process, there was this question of could member state have a bigger role, and what are their roles? I would say outside of maybe national courts who could enforce the regulation directly, which we will still see whether or not this is possible. I think it's really all with the Commission and makes, in my view, a lot of sense. I was just always asking myself, how much do you talk with each other? But it seems to be a lot. I mean, within DigiComp, it's not such a big issue to go to a different floor and ask the merger colleagues how they are doing in the case. Maybe a small back question towards Eddy is that, you know, you said earlier in the Sieg test, you know, you don't apply this with regard to the FSR, but in the Sieg test itself, financing of the merged undertakings is one aspect to be considered. Is now in the merger test this part out of the test altogether, and does it completely lies with you, or is this issue of, okay, it's a foreign or a subsidized company not an issue anymore? Because I think here, you know, the nuances between both, or there is an overlap between both regulations. So yeah, but if I can give my 2 cents on how the regulation works, I would say the model it picked overall with being at the Commission and having these three different enforcement tools, I think makes a lot of sense. Also because in the past the cases there where we didn't have a foreign subsidy regulation just yet, it was mainly, you know, in concentrations and procurements. Yeah.
Thank you very much. Eddy, are you okay with reflecting a bit later once Marek comments on the new enforcement mechanism? Marek, please.
Yes. Oleś, can I offer you my third animal? So of course we touched upon this, but we talked about fish and we talked about dogs, but of course the animal in the room is China. And that's the elephant in the room, right? I had the pleasure to talk about FSR in China as well, and there was a wide perception of this being anti-Chinese law, right? I think it's important to raise this issue We've discussed it already quite a bit, but let us underline that this is law of general application. It will apply to firms from all over the world. And indeed, many colleagues in US believe this is anti-US law, right? And Lena earlier mentioned the question of to what extent this will apply to European firms. I do believe European firms are sometimes getting state aid, so subsidies also in foreign countries for a variety of reasons. Sometimes they are tempted to come and bring technology. This is quite often within industrial policies of different countries. And now they'll have to pay attention also to these rules. And they'll have to face the cost of compliance, and they will have to start collecting and organizing information about the aid they get in a variety of locations, which I think is very important. But allow me to go for a moment back to the point Eddy raised about different parts of Commission dealing with this regulation, because here, Eddy, you talked very nicely about DG Growth and DG Competition acting separately, autonomously in this regard, right? And Lena talked nicely about the possibility of running, for that huge building and talk to colleagues from other teams. I think that distance-wise, this may not be challenging, but in practice, it may be. Because as we said at the start, this regulation sits on the interface of different rules. So colleagues come to enforcement of it with different mindsets, right? Colleagues from procurement may have different mindset than colleagues from mergers, right? And they'll have to somehow make it work. And of course, so we have different teams in the Commission. Then we have different national FDI rules. And of course, other regulations come to play, right? We can think about Digital Markets Act. So I think there may be quite a bit of challenges when it comes to coordination of enforcement in this area. And I think I would not undermine difficulty of this. I think Commission is very rightly taking slow steps with precaution, because this is really an interesting new area and requires careful steps. And perhaps I stop here. Thank you, Oleś.
Thank you, Marek. I propose we change slightly the order. So we'll let Eddy answer or reflect upon these comments by Lena and Marek, and then I'll ask Lena to continue with a new set of questions on procedural aspects.
Okay. So first on Lena's question whether the FSR changes anything to the EUMR enforcement and the role of financing there, the short answer is no. There is no change whatsoever. The only role that financing could have in the context of a CA control is to check to what extent the financing that a company has may play a role in creating that dominance. Well, I should not talk about dominance anymore. Create that significant impediment of effective competition. The financing there in the EUMR can be both financing by a member state or by a non-member state. So it is not linked to foreign subsidization. It is the financing as an element of creating of contributing to the CA. So that does not change. That does not change with the FSR coming into force. And on what Marek said, we know that the stakeholders quite rightly expect us to take a homogeneous approach in the enforcement of the FSR. And that is why we have regular contact with the GROW colleagues, even before adopting decisions on finding distortions. And so already now we discuss in early stages of cases, we discuss concepts. You can imagine once the Commission will come out with a decision enforcing the FSR, that the contacts with DG GROW will even be closer. So that's a point that is definitely taken, and within the Commission, all will be done to ensure that there is a a homogeneous enforcement.
Many thanks, Eddy. Lena, so procedural mechanism, what are the main components?
Well, we already said that there are two notification procedures, and they, yeah, I would say specifically when it comes to merger control, they're very similar, that they have two phases. So an initial investigation phase and then an in-depth phase. And this is the same holds true also for the other notification and procedures. So we have, as we usually have in DG Com, two phases. And I would say the enforcement, so the procedural tools are very close to what we know already in competition law. So there's RFIs, there's the possibility of inspections, and then of course also the possibilities of inspections outside of the European Union, a tool. That's why I always say that's the cherry picking regulation, a tool I think that was picked from EU trade law. So of course, outside of the Union, you know, the Commission has to rely also on, let's say, the goodwill of the third states. And that's why something, I think it's Article 16, but it's a tool where you can assume, you know, specific facts if third states and companies do not want to cooperate. So let's say a little bit of a better judgment rule in case of non-cooperation. I think that's for competition lawyers something very new, you know, because in competition state aid proceedings, the burden and the standard of proof is quite high. And if you cannot, if the burden of proof is on the Commission and you cannot prove it, and this is due to non-cooperation, you cannot, you know, simply assume points. So I think it will be very, very interesting how this will play out in practice. And then in the end of the procedures, there can be various types of decision and remedies, but I think we will touch upon this more later. So when it comes to at least the Commission proceedings, as I said, very close to competition law, but with some new tools that can be used. And then, as you know, before I turned my interest more to foreign subsidies, I was more dealing with private enforcement of competition law, and so like one thing I looked into when I looked into this regulation, is this privately enforceable in national courts? And you know, just this morning I gave a lecture on like EU law 101s to these students who learn EU law from the first semester, and what you need for direct effect. You know, something needs to be clear, precise, unconditional. And then if you compare it a little bit with what we have in private enforcement of competition law, I think 101, 102, this is non-debatable that we can enforce it in national courts. When it comes to state aid law, we have standstill obligation, and that gives us the basis for private enforcement. Well, the FSR has standstill obligations for notification procedures, but not for the ex officio tools. And for the ex officio tools, I really have my doubt on the possibility to enforce this in national courts. Because, you know, Eddy talked about it earlier, on the second stage, the phase 2, you look into this balancing test. And so at least in my view, I think the provisions in the regulations are not as precise enough to have direct effect in national courts when it comes to the balancing test. So it's the same, by the way, in state aid law. And if we want to have some kind of equal enforcement, the court said that, well, for state aid law, there's no direct effect for the prohibition of state aid, so to speak, but only for the standstill obligation. And since we do not have that, at least not, you know, for the ex officio tool, I would say in that regard, also no direct effect. But, you know, maybe the court will surprise us, but that would be my take on the issue.
And I wanted to ask you on the side, you scrutinized the history of private enforcement. Was it a revolutionary judgment, the first wave of private enforcement of private enforcement cases in the EU? So was it a big jump, or we gradually were moving towards this?
I mean, it was a big deal, and you know, also Eddy can say some things about it, because he was in the private enforcement unit before, so he also knows that aspect of competition law really well. I mean, Courage and Manfredi, these first judgments in the beginning of the 2000s when it came to private enforcement of competition law, were big deals in the sense that it was the first, big judgment on EU level. But you have doctrine and academics who've been talking about this for 30, 40 years, that you have, you have private enforcement, or you should have private enforcement of competition as well. So it at least, it started a big, regulatory debate with the damages directive. And if you look at the numbers of cases we have had a huge increase afterwards. So it was a big deal.
Thank you. Thank you, Marek.
Thank you so much. Let me pick up on some of the points Lena already highlighted. The regulation brings a variety of interesting ideas. Lena mentioned, for example, the issue of facts available. The fact that if we don't have a complete picture, a commission will work on what it has, and that indeed comes from the trade law. So that's quite interesting. We hear that Commission is wishing to conduct inspections outside the EU with permission of foreign states. Of course, this is an example of extraterritorial enforcement jurisdiction which Commission doesn't have. So absolutely, Commission will need to have a permission of a foreign state to be able to do this. And of course, the question arises: what if the firm says yes and the foreign state says no? Foreign states may say no, not because they don't like Commission, but they may have a specific view of international law in this regard. The question is, can you really draw inferences from their view about international law? I'm not sure. We also have interesting approach to non-cooperation. We find here a provision that inferences may be drawn if foreign firms, or generally firms receiving aid from some subsidies from foreign countries, provide a misleading or incorrect information. Commission may base on such basis, but the same is said about a third country providing misleading or incorrect information. This is quite interesting that the regulation foresees a situation when European Commission will be judging correctness of information provided by another sovereign state. Hopefully we will not have tension here, but is this justiciable? Can Commission sit in judgment on understanding of rules operating in other countries? This is not in a way unusual, because we had cases of similar sort already in competition law beforehand. As you may know, I've done quite a bit of work on state involvement in anti-competitive conduct, and we had this, for example, raised not long ago in relation to Chinese export cartels that were sued in the United States, and we had a similar case in trade law, and different representations were made by Chinese authorities. We also had an interesting situation in past with same countries speaking with different voices. So I recall a case involving foreign firms and their governments. That was actually, I believe, Japanese government making contradictory representations to a US court. And that's another challenge, which potentially shows how this regulation very much sits on the interface between law and politics, because we may end up with very complex scenarios. And to add one more layer of complexity, I think we weren't explicit about it, but of course this regulation applies not only to rules of a federal level. We have variety of countries that grant subsidies at different country levels, like for example in China, that we may have different provinces within China taking different steps. I recall discussing this issue with a colleague from China, a business person, who was telling me that they find it very difficult to comprehend some of the state aid rules, so subsidy rules on subsidy in different provinces of China. If Chinese colleagues may have problems internally comprehending this, how feasible it will be for the Commission to go about it? Because the obvious danger, of course, is that a European competitor will be trying to use Commission to undermine competitors by means of imposing a compliance requirements, extra checks, and asking effectively Commission to to take action to undermine, take away their attention and focus, and maybe to scare them away from the European market, right? So I think this may be a challenge. Thank you.
Thank you, Marek. Eddy.
Thank you, Oles. A few points. I think that Lena mentioned, I think now a second time, that she calls the regulation the cherry-picking regulation, which I hope makes that we are a blossoming cherry tree. It's true that we have been learning from other regulations, and the trade colleagues helpfully informed us indeed of the usefulness of the facts available tests that they have in the anti-subsidy regulation, and which we can also use in this context. Obviously, I know, as Marek pointed out, that in this case we would also have the possibility to rely on the facts available in case the third state is not cooperative. Different from the situation in a state-to-state conflict, we always work here towards, I mean, the eventual decision will be addressed to the companies, and some companies could always either contradict or complement the information from the third state. What we want to avoid is that companies are hiding behind the third state and saying, very interesting question, but unfortunately I cannot tell you. It's a military secret. It's something that if I tell you, I'm risking sanctions in the third country, what have you. So a company could hide behind the third state, and if then the third state could remain silent without any consequence, then that would mean that we, as the Commission, would be in a deadlock. Hence, if both the company and the third state refuse to answer to our requests, we can still go ahead. And we cannot be blocked by this double lock of the company and the third state. That is the reason behind also having the non-cooperation by third states in that provision. On the inspections in third countries, I mean, it has never been our intention to do surprise inspections abroad without the third country being aware. That would be extraterritorial. It would be very undiplomatic to do so. But different from the anti-subsidy regulation, we do not need to ask for the consent of the company that we are visiting abroad. So we may have a situation where the third state agrees. I mean, the third state is everything but the 27. Eh? You don't only have to think of the same third state. It's anyone apart from the 27, where the third country may agree, and then we can come in without pre-warning the company that we are visiting. So I'm not excluding at all that we will have surprise visits in third countries. Yeah, I could say something on private enforcement, but I'll leave that for another session.
I would just one quick thing on cherry picking. Didn't say that was necessarily a bad thing, and I think you've just said like the one example, where it made sense to see, the deficits in the anti-subsidy regulation, where you need to, ask the permission of the companies. I could even think, it's good that regulations or the regulatory process in the European Union is a little bit inspiring each other, and you see, what works in one aspects doesn't work in the other aspects. And in that sense, especially we talked about this Article 16, the facts available, see what kind of potential there could be, if you would have a similar provision also when it comes to EU competition law. Look at digital markets, where we always talk about, reversal of the burden of proof, who needs to bring forward what. And, I remember last year I was at a conference and one of the Commission officials talked about, spamming the regulator, companies who really, specifically large digital companies who really prevent EU enforcement and to have more of these rules that facilitate enforcement. I don't think it's a bad thing. And in that sense, we can also ask ourselves now, what can we learn from the FSR? And if this provision is applied, very sensibly, I think we could think about having this in other areas.
Thank you. Marek, you wanted to say something as well.
Maybe to add to what Eddy said about cooperative nature or cooperative attitude of foreign states. Of course, the moment they are cooperative, the situation is much, much, much easier. But as an academic, I like to look into the other direction, where a variety of interesting problems may arise. And of course, one of the things that I find quite interesting, I've written on this in the past, is the issue of foreign state compulsion. This is a well-recognized defense in competition law all over the world, whereby sanctions are only imposed effectively for autonomous conduct. Hence, it may happen, in theory at least, that a foreign company says, I cannot disclose this information to the Commission because my government tells me I cannot. And I cannot believe European Commission from that fact itself could draw adverse consequences, right? And of course, we had foreign sovereign compulsion coming to play in a variety of cases. And of course, in practical terms, this will be usually cases involving very different ways of organizing domestic economy, when we will not be easily able to understand complexity of another system, right? Because when it comes to similar systems, this will be much easier. So there may be a clash there as well, although I don't think it is very likely. Thank
you very much, Marek. Eddy, there is a temptation to ask you maybe to condense your key points about private enforcement. You have a lot to say, but it will be interesting. And then we move from policymaking poetry to legal prose, and ask Lena to continue on these procedural aspects, looking at burden and standard of proof, efficiency defense / balancing test, remedies, commitments, this part of the story.
No, I will not dwell too long on private enforcement, and indeed, let's see what the court makes out of the FSR. No, but simply to respond to your question on what did courage do, and was that a culmination of what existed already for a long time, or did this really come out of the blue? And Lena replied already that in doctrine, the feeling of private enforcement was there. But for the regulator, courage was important, because since the court identified damages as an intrinsic part of our primary law, that was a stimulus for the regulator to then facilitate, and because that is what the Damages Directive is doing. The Damages Directive doesn't establish the right to claim damages. That is established by the treaty itself, if you read the court. But we facilitated that, and we found in courage and a stimulus and a motivation to do so. So in that sense, courage was an important case law.
Okay, so and now, Lena, let us revert to the procedural aspects, remedies, obligations, standards, burden.
Yes, so maybe let's talk a little bit through the procedure. We said it already together with Eddy. It has two phases, so preliminary review phase and then an in-depth review phase. And in the preliminary phase, there's, in high-level terms, a basic check on whether or not we have foreign subsidy and whether or not it could be distortive, and then the question of whether or not there's a distortion on the internal market. And the balancing test has only been taking place on the second level. So only then, when we enter phase 2, so to speak, will there be the in-depth question of distortion on the internal market and also the balancing test. As usual, the burden lies with the Commission to prove distortion. The undertakings can bring forward, any positive effects. Speaking of, in the context of the DMA, we always talk about efficiency defense. Efficiency defense is part of this balancing test. And under the balancing test, Article 6, really a very, very interesting provision. For many reasons, you know, because it's very short and it basically says, well, all the distortions, the negative distortions on the internal market can be balanced with positive effects. These effects do not have to be economic effects per se, you know, so it's not a distortion. And then efficiency defense, as we know a little bit from competition law, that it needs to be, you know, connected to the market and connected and to bring some kind of efficiencies on the market. It's more, you know, general positive effects. And in the recitals towards the regulation, you can see, for example, positive effects, you know, on the digitalization of the internal market, or you know, to promote the EU Green Deal. So there can be really any positive effects. And in practice, it will be very hard to, you know, balance a distortion on the internal market with any, let's say, non-competition related positive effect. All these discussions we've had for the last, you know, couple of years, greening competition law, and how can, you know, sustainability play a consideration here, at least from the wording, it could be very, very easy to take into consideration positive effects, but they have to somehow outbalance the negative effects. However, this may take place, you know. It's really, it will really be interesting to see. And here, if you compare it with state aid law, the underlying rationale in state aid law, so 107(2) and 3, is also a balancing test, but there you have detailed criteria and you have detailed guidelines which give you a specific amount of aid or specific areas where, you know, I don't know, R&D aid can be paid out, and that you do not have yet, at least for the foreign subsidy regulation. So it is now much more open. So from a procedural point of view, very interesting. And once we, you know, this, the procedure with the 2 stages is over, there are possibilities for various decisions. Of course, there can be a no objection decision. And in all 3 procedures, there can be a commitment decision. So undertakings propose commitments, and then the Commission can make them binding. So in ex officio, but also in the 2 notification procedures. When it comes to, let's say, the negative decision in ex officio, that means that the Commission can set redressive measures. So even if the undertaking does not propose commitments, the Commission can impose redressive measures. And for the notification obligation, the negative decision is the prohibition decision. So it could lead, you know, the procedure under the FSR could lead for a concentration to be entirely prohibited because of a foreign subsidy. It's not only paying back the subsidy, then the concentration itself can be prohibited. And then, you know, I mean, Eddy will not be happy about this, but, you know, when it comes to commitment, we have cherry picking again. So we have all these possible commitment redressive measures that we know from competition law, state aid law, but also trade law, all kinds of merger control law. So from granting access under front conditions to refraining from certain investments, from R&D divestment, dissolvement. I think in practice, repaying of the foreign subsidy will be very crucial. And then the question repaying to the Commission will be something we can envisage, but we will see, you know, if this will be applied in practice.
Thank you very much, Lena. Marek.
Well, the one issue we didn't really touch upon in all this, talking about the procedure, is the burden on firms in this regard. And I think this is very significant. I had an opportunity to discuss that with a number of practitioners. And this is the biggest issue they are facing, they are seeing, right? So the question is, how do you comply with all these notification requirements stemming from different systems, also not only at the EU level, but also as FDI control at the domestic level? There's quite a bit of realignment and coordination that will be necessary. And at the moment, we are simply not sure how this will play out. What is clear is that quite a bit of red tape. So lots of transaction costs being created in this.
Thank you very much, Marek. Eddy.
What we will do with regard to the remedies? is in order to restore the level playing field. And that is, as you heard, as I said in the beginning, and the rationale of the FSR is to ensure that level playing field, ensure that companies that remain welcome on the internal market, that they are competing on the merits. And that is what the remedies are going to do. Once a distortion has been identified, impose on the companies structural or behavioral remedies to repair the level playing field. A few examples are mentioned in the FSR. In the context of concentrations, as we know it also under the EUMR, there we wait for the companies to offer the commitments that they want to offer in order to remedy the distortions that we are identifying. And if we find that those commitments indeed restore the level playing field, then we will accept them through a decision. If not, we may go as far as prohibiting the concentration. So that is the toolbox that is available to us. There is obviously also the possibility to repay the subsidy, but that has to be a real, an effective repayment. It cannot be that you repay with the left hand and that with the right hand you give the money back to the company or a subsidiary. So it has to be money that really flows back to the budget of the foreign state, and it is no longer available, also not indirectly, to the beneficiary. And
Eddy, can I ask you one small thing here?
Yeah.
Because it's not in the regulation, and because the list of remedies, you know, it's open, you can pick something that's not in the regulation. Could you, or I mean, maybe you will not say something regarding this, but would you consider a pay back of the foreign subsidy to the Commission, or is that something out of the question? Because whenever people ask me about the regulation, how can you ensure that's actually paid back to the third state? Couldn't the foreign subsidy be paid back to the Commission, you know, as kind of not a fine, but, you know, as taking it away and ensuring that it stays away?
That sounds very much as a fine, and it would not necessarily create the level playing field. So, however tempting your proposal sounds, Lena, I don't think that it is appropriate that we get an additional money into the European budget through the foreign subsidization.
Marek has a question as well.
If I may, I found the aspect of the balancing test particularly interesting, of course. And one issue which I find quite interesting and worth touching upon is the extent to which Commission can take into account any raised positive consequences into account when they are located outside the EU. So the question of sort of positive externality. What if foreign firm that, or a firm simply that received subsidies outside the EU says there will be some amazing environmental benefits somewhere else, and that's sort of easier case because maybe environment is a one ecosystem. And what if there will be positive developments to happen outside the EU that would be of socio-economic nature? Would Commission be willing to take that into account, its own balancing? Thank you.
Now, there can be two situations of positive effects. Either the positive effect of the subsidy is a positive effect that outweighs the negative effect, in which case we are ready to drop the case and not to find that there has been a distorted foreign subsidy. Because, again, the eventual objective being that there is a level playing field, if there is a subsidy that is having such positive effects that also the distortion is outweighed by that, then we will accept that. An external positive effect I have difficulties in imagining how an external positive effect could undo the distortion within the internal market. So if anything, an external positive effect will affect the kind of remedy that we are going to impose, in the sense that we try to preserve the external positive effect, but there will still be a need for a remedy in order to restore the level playing field. Whereas if the positive effect is also taking place on the internal market, that's a weighing that we can do on the internal market. And so, yes, we would accept external positive effects, but as I said, I think it's difficult to imagine how that can outweigh the distortion on the internal market to an extent that we would not impose a remedy.
And now we move to the animal, which is new for many of us, but not for all. Supposedly the mechanism is quite known. Anti-circumvention. We discussed a lot about these issues when in the context of the DMA, knowing that there are so many ways to take the letter of law while not complying with the spirit. Here, it looks that the room is even more broader. How to facilitate, how to arrange this support. If you as a public entity, I imagine, are keen to support company, even if millions or many millions at stake, there are probably different ways to do it directly, less directly, or even secretly. Lena, how do you read this provision? Is it organically even enforceable?
Well, I think it's just some of these trend provisions that appear now in the modern regulation on EU level. As you said, we have it in the DMA, we have it in a lot of regulations. I think it's more, emerging as also a general EU law principle, in the sense that if you try to circumvent EU rules, there should be, a fallback provision. The problem with all of these anti-circumvention rules is a little bit, where are the boundaries? I mean, I know that in the regulation, a lot of consequences are connected with the anti-circumvention provisions. So fines specifically are also connected with anti-circumvention. I think it needs to be similar with the DMA, more blatant than indirect. And with the FSR, I think it's even a little bit more complicated, because the notion of foreign contribution, as it is very, very close to the notion also under state aid law, it is in itself very, very broad. So it does not only so the definition of a foreign subsidy does not only cover, direct payments, but it can be loans, it can be tax measures. So I think it will be very, very hard to find, areas where you would even need this anti-circumvention rules, specifically when a third country tries, to circumvent the foreign subsidy definition, because I think there, from what I know from the state aid jurisprudence, the notion is so broadly understood in state aid that basically anything positive, negative kind of financing is already covered. I think anti-circumvention plays, if all, a big role in the procedures again. There we have this best evidence available already, and anti-circumvention is just like, to pick again the same kind of fruit, the cherry on top, meaning that, it's just something extra that if any of the obligations on undertakings that they have to follow up in the procedures, that this cannot be circumvented, so notification specifically.
Thank you very much, Lena. Marek.
Thank you so much. I think challenges may present themselves specifically in cases when we're dealing with very different ways of arranging domestic economy. So we have very different rules and very different systems. And indeed, in competition law, we had in past these challenges presented, for example, back then by Japanese economy in relation to whether guidance provided to firms, whether it was mandatory or not, whether it was law within the Western world understanding of state compulsion, or whether this was a recommendation, right? And Western countries grappled with that question quite a bit. And I expect that we may find sometimes difficult cases when simply we'll be dealing with very different ways of organizing things. As Lena very correctly pointed out, the rules quite broad, but of course the devil will be in the detail, how we go about their application.
Thank you very much, Marek. And Eddy?
The anti-circumvention provision was introduced during the legislative process as an additional tool to avoid that certain concentrations would not be brought to our attention. And those of you who have followed a bit the legislative process may remember that between the Parliament and the Council, there was quite a debate on setting the thresholds above which there was a need to notify a concentration or a public procurement procedure. What the Council and the Parliament eventually agreed was to settle the threshold at the level of the Commission proposal, though if the Commission would see, and then it's particularly with regard to the subsidization, that some foreign financial contributions are being disguised in a way that it is not identified as a foreign financial contribution, and thus no notification because of that reformulation of the foreign financial contribution, that then nevertheless we could intervene. And that was the objective of the anti-circumvention. It's a bit, as one says in French, ceinture et bretelle. So really every safeguard possibility to avoid that companies would not notify. I must say now, after a couple of months of enforcement of the notification obligation, that in the field of concentration, I cannot speak for public procurement, that in the field of concentration, I have no indication of companies avoiding the notification obligation. And that may have to do with the fact that in the implementing regulation, we have facilitated the notification obligation, the reporting of foreign financial contributions. That is no longer considered to be a disproportional administrative burden, and is therefore not frightening companies in coming forward with notifications. But it's good to have the anti-circumvention provision in the regulation, and let's see whether in the future any case would pop up where we would invoke the anti-circumvention provision. But for the moment, as I said, I see no need to do so.
And now we move to the end of our really amazing, for me at least, really fascinating conversation. And we have the tradition of closing it with recommendation to our students. But I want to break this tradition a little bit, or refine it maybe. And Lena, ask you before reverting to the recommendation for a challenge and congratulation on your another concurrence award nomination. So you have the paper, The Role of Third Parties in the Enforcement of the Foreign Subsidies Regulation. Can you provide us the summary of the paper within 90 seconds and then revert to recommendations?
Yes, of course. I mean, it deals with the 4 aspects on how third parties can be involved in the FSR and any kind of procedures. And there, you know, as the FSR itself, I inspired myself with other areas of EU competition law enforcement. And so it deals with the question, can third parties be complainants? And, you know, of course, they're not prohibited to bring about information with the Commission, but they don't have similar rights as complainants. So there's the Commission is under no obligation to follow up the complaints, and that's different in, you know, competition and state aid law. And we see that, you know, in the DMA, they also do not have proper rights as complainants. So you see again a trend of modern regulation not giving complainant rights, and that's an issue for a whole different kind of webinar we can have. so deals with complainants. Then how can third parties be involved during the proceedings? So how can they provide information in the sense, you know, be subject to RFIs, inspections? How can they ask for judicial review of any kinds of decisions? So, you know, imagine your competitor gets foreign subsidy and the commission say it's fine. So how can you, as a third party, apply the judicial review provisions at the European courts, which is limited in state aid law and, as far as I assume, also under the FSR. And then a topic we've already discussed today, so private enforcement, because you see the possibilities to at least make the commission enforce the FSR if you want to, when your competitor gets foreign subsidies, is very, very limited. Then the question is, can national courts jump in? And as I said earlier, when we have standstill obligations, so under the notification obligations, there's a standstill period. And for that, I think direct effect is there, and as the underlining factor for private enforcement. For the other provisions under the FSR, I'm less optimistic. And even for these standstill obligations, Eddy also mentioned it earlier, you know, we had the Courage jurisprudence, we have the damages directive, we have a lot of national case law, a lot of national laws on how competition law and to some degree also state aid law can be privately enforced. We have nothing for state aid law, for FSR, which makes it interesting for research, you know, happy me, I can write more papers on this, which have more awards in the future, hopefully. But you see, you know, there's no guidance. So issues that are there in private enforcement, such as, you know, quantification and disclosure and all of this, we don't have it for the FSR. So private enforcement, in theory, to a very limited degree. And that's what the paper is about, yes.
And now a recommendation.
Recommendation for students, well, the FSR itself, you know, fascinating topic, but I would say in a more broader sense. So I would, and I know people are researching, you know, in the area of the FSR as a trade tool and so on, but I would look even a bit further. So this whole issue of, you know, geopoliticalization of competition law, and I think there the FSR is a very important aspect, but we should go beyond that. I think that's a super interesting aspect of research. So in that sense, you know, there's so many areas where you can delve future research into, and you know, it's a nice area of work. You know, you can spend your afternoons discussing with you. It's better than compiling RFIs in a law firm, I can tell you.
Thank you very much, Lena. Marek.
Thank you so much. A recommendation for students. At Queen's in Belfast, we have quite a few students from all over the world, from very different cultures and different countries. And I think this regulation shows how valuable it is to study both competition law and trade law as it's two different sides of the same coin, right? And it creates so many interesting employment opportunities for students in future, for professionals who will be needed to work in this area. So if you are interested, do study and come to do it with us in Belfast. We have a lovely LLM on international and comparative commercial law, and explore these issues on a regular basis. So please come to Belfast.
Thank you very much, Marek. Eddy.
The recommendation to students is to do a thesis on the foreign subsidy regulation, which is a new piece of EU law without any case law for the moment, with inspiration from several other sources, as you have heard throughout this session. And you may, with a very creative spirit, interpret the provisions of the FSR. Recommendation 1. Recommendation 2, after you have done that thesis, come and do an internship at the European Commission. There is always a place at the FSR team for you where you will see the enforcement alive.
I can tell you there are some students out there who are writing a thesis on this.
Marek Martyniszyn, Eddy de Smijter, Lena Hornkohl, thank you very much for your fantastic contribution to this panel. It was really a pleasure to learn a lot from you, and thank you for this interactive and very engaged dialogue.
My pleasure.
Thank you.
Thank you